This screenshot video is just a short uh, ex- exclamation explanation. I know I could say that regarding this article I posted, which is very complex. I appreciate that, but I wanted to give you an example of how some of the basic rules of contract law that we're talking about, in this case, it's the rules on agreement, can lead to major litigation. And we have three main players in this article. We have Getty Oil Company, we have Pennzoil, uh, which was an oil company, and a third corporation, Texaco. And I've put the screenshot at a point in the article where things start to happen in a way that we can appreciate a little bit the dynamics. Basically, uh, Pennzoil had been interested in purchasing all or part of Getty Oil. Pennzoil was looking for, as they say in the article, oil in the ground. Texaco also was looking for oil in the ground. In other words, these two companies wanted to purchase some or all of Getty Oil to get access to oil that could be used as opposed to exploration rights or other assets in the oil industry. In any event, what eventually happens is that Getty Oil and Pennzoil had apparently, and I'm using apparently uh, in a very meaningful way because there was different takes on it, apparently had reached some understanding that Getty Oil would be sold to Pennzoil. And the way that works in the corporate world is a merger. And a merger, if you will, is just a form of a contract. It could be considered a big deal contract, but a contract nevertheless. So what happens, and this is all in early January 1984, is that uh, Pennzoil believed it had made a deal. Getty Oil was uncertain. And as you can see, and I'm scrolling through this, Pennzoil legal staff hadn't yet produced the final merger documents. At the same time, roughly, that is happening, Texaco is meeting with one of the larger shareholders in Getty Oil, namely this Gordon Getty, and they eventually, in the same time period, reach a deal. Uh, so now, uh, at least Texaco and Getty Oil believe that Texaco had just purchased Getty Oil. So Texaco announces that it had acquired Getty Oil, but Pennzoil, believing it already had a deal with Getty Oil, brings a lawsuit in Houston, Texas. And as the writer of the article points out, for wrongful interference in a merger agreement. And now we're not talking, at least as that claim is concerned, about breach of contract, but something known as the tort of interference with a contract. So what Pennzoil is claiming in the lawsuit is we had a contract with Getty Oil and Texaco interfered with our contractual rights as evidenced by the contract between Texaco and Getty Oil. And Pennzoil claims that its damages is $7.53 billion and 7.53 in what we call punitive damages. And sometimes in the civil law, not for breach of contract, but for torts, in this case, the tort of interference with the contract, a court can award not only your actual loss or your actual damages, but punitive damages. So now we have a trial, which was somewhat fascinating because what Getty Oil does is it hires a very colorful and famous and very skillful trial lawyer in Texas, Joel Jamal, as he was known as the king of torts, but his torts usually were personal injury types of cases. And so what happens, and it's not in the article, is Jamal is trying the case on behalf of Getty Oil in front of his people in Houston, Texas, because that's where he practiced law. And he's backed up with all kinds of corporate lawyers that Pennzoil had hired for him to do the backup. And Texaco is represented in this lawsuit by a large uh, Houston firm. And as you can see, Jamal and his team uh, had the strategy that they were good local guys. Pennzoil, I might add, was an Oklahoma corporation, and we're up against this New York City corporation, etc. And a lot of the witnesses, as they point out, were Wall Street investment bankers and lawyers. And quite frankly, Jamal feasted on them. So, and there's a claim made uh, in retrospect that the lawyer for Texaco may have made some strategic blunders during the trial. But what happens is the jury favored Pennzoil's position and awarded Pennzoil $7.53 million in actual or compensatory damages and $3 billion in punitive damages. Texaco wants to appeal, but one of the problems is, unless you're a municipality, when you appeal a case where a money judgment has been taken against you, you've got to post a bond, which is kind of like an insurance policy. And generally, that's dollar for dollar that it costs you to obtain a bond. And in this case, it was impossible for Texaco to come up with $11.1 billion. Uh, and eventually, because Texaco couldn't get adequate relief to even appeal the judgment, it files a petition in bankruptcy court. And it's a Chapter 11 petition, which is different than a petition in bankruptcy where you're trying to dissolve the corporation. You're trying to stay in existence and work out some kind of payment plan. Eventually, an agreement is reached where Texaco keeps the Getty assets, but it has to pay Pennzoil $3 million. So the point perhaps of having you read this, other than again, I think it's interesting and it shows a real world application of some of the principles, is that when we talk about offer and acceptance and we look at our rules, sometimes we have questions of fact. In other words, we talked about a valid offer, and we talked about a valid acceptance, and then when the acceptance is effective. And in this case, factually, uh, Getty Oil was mistaken when it believed that uh, it hadn't yet accepted Pennzoil's offer. It had. And the results, perhaps due to also some, as I said, strategic blundering, but the results were disastrous for Texaco. So the good news was Texaco ended up with Getty Oil, but had to pay an extra $3 billion to Pennzoil to settle the tort claim that Pennzoil had against Getty Oil. In terms of the significance, again, I think this is interesting background, uh, but it doesn't specifically relate to contract law, so I'll let you work your way through that. And by the way, if you have any questions about this, just send me an email. Please try to be specific, and I'll try to then answer it. I'm not asking you to master the facts of this transaction. I'm just pointing it out to you regarding uh, how what seem to be the simple rules of offer and acceptance, because sometimes of their factual background, can lead to significant litigation. And lastly, let me just say this. If I were to ask you any questions on any evaluation experience regarding Pennzoil and Getty Oil, basically my summary here is going to highlight what I would be looking to receive from you. Thank you.